Okay, interesting question. You attended an IEP meeting with a family member in Connecticut. The district had an attorney present from one of the biggest surrounding firms, and the parent was blocked from equal participation by not being provided the opportunity to share the student work product or have questions answered. The parent also requested to reconvene to gather thoughts and triangulate data, and the attorney refused, resulting in the student being exited. Your question is this ethical? What is the appropriate action for the parent at this time? Okay, number one, is there any kind of bright line rule? And you might want to check your individual state, but I'm talking about the IDEA in all 50 states. Is there some kind of prohibition from attorneys participating in IEP meetings? No. Now, as far as some kind of, I don't know, best practice, it's highly discouraging, or it's highly discouraged to have attorneys participating in IEP meetings, or in meetings where, let's say, an advocate is there, or a meeting where no attorney and no advocate is present. How some schools get around that, and like I said, there's no rule that prohibits an attorney in there. The only thing that it does is it does really tarnish the school district with regards to arguments that can be made, like equal participation, parental equal participation. You can also make arguments that it was a non-conducive environment, that the attorney was the one that led the meeting. The attorney was the one that directed the outcome. At that point, you would have a fairly strong legal argument that the school wouldn't necessarily have good defenses to come back and say, well, this was necessary for X, Y, and Z reason. Where a lot of schools sort of get away with having the attorney there is sort of in the corner monitoring. And, they sit there and they come up with that excuse that the board attorney is there to ensure that procedure is being followed and to provide guidance, but does not necessarily direct the ship, or is directing the meeting, or is really piping up that much. And that's in meetings to where the parent doesn't have representation, meaning that they don't have their own attorney present. So I am by no means am I making some declaration that it's illegal or unethical to have an attorney present in a meeting when the parent doesn't have an attorney. Is it appropriate? No, it's not appropriate. But appropriate is not illegal, guys. Just like being an a-hole is not illegal. The world's full of them. Okay, I've been accused of being one many, many times. It's not illegal. Is it appropriate? That's different. It's not appropriate. Does it foster agitation? Does it create a hostile environment? Is it oppositional to the goal and purpose of the IDEA? All of those things, the answer is yes. And so it infuses this negativity and this heightened sense of angst in a meeting that it's not supposed to be there. All right, and it's supposed to be a collaborative relationship between the parents and the district. And an attorney is not an educator, and an attorney is not a natural member of an IEP team. In fact, it's not even a secondary member of the IEP team, like related service personnel, like speech language pathologist or board certified behavior analyst or OTs. There is no attorney back there. The only time the attorneys necessarily step in is when there is some kind of formal complaint. And I don't know enough about the details of what your question as far as the backdrop. It sounds like to me that there was already sort of some questions with regards to continued eligibility, and the district had this person there. Well, whoever this attorney was, I don't know their history, I don't know their personality, but it sounds like to me that they sort of screwed up in taking a larger role than they should, than is appropriate. And like I said, what does that do? Well, it lends a very strong argument that that parental right was in the entire process was not appropriate with regards to exiting. But you got to be careful there, because at the end of the day, whether this person was there or not, the reliance by any hearing officer or any federal judge is going to be on the evaluation data. These other things can be contributor, like supporting actors, but the big central argument is going to be, what does the data show with regards to your child's or the child's entitlement to, or the need, that's the right word, the need for specialized instruction or the continuation of specialized instruction. There's no question that the child still has a disability. It's just whether or not they require specialized instruction. And if they say, well, he doesn't need specialized instruction anymore, that doesn't mean or negate that the child still has a disability. That just means that a 504 would need to be discussed instead of an IEP. So I don't know whether they did that. That's another violation. But at the same time, if you're saying, yes, my child still requires specialized instruction, they didn't fully consider all of the data, yes, that's something you can make an argument, and that would be through due process. You can also make an OCR complaint separate, saying that this attorney was present and violated your parental rights under these, and then have OCR deal with the investigation aspect of it, because the Office of Civil Rights has attorneys that love to latch onto school systems, and they love these type of violations, and then they love spanking board attorneys that do this kind of stuff. So that's an option, but it doesn't negate, if you have OCR involved, it doesn't negate your ability as a parent to then trigger the process for independent evaluations paid for by the district, for a secondary review paid for by the district with professionals of your choosing in the areas where the child was assessed, but then also bringing in your own information. And if they deny those requests, then they're the ones that need to file due process to defend their evaluations, and the burden shifts over to the school system. So there's some options there, but like I said, remember that the fact that the attorney was there, sort of interfering in the process, the natural process, doesn't negate the substance of the evaluations. It just becomes a supporting theme as to why the full parental rights weren't considered, along with your data wasn't considered. And that can be a strong argument, but that isn't a singular argument. The singular argument needs to be and remain focused on, my child still requires specialized instruction, and this is why. And this is the documentation to support that. And this attorney, by their presence, impeded the consideration of this data. And if you can sit there and support that your child still requires that specialized instruction, then this aspect only enhances your argument, okay?